I'm Harwell Wells of Temple University, and we're here in the New York offices of Debevoise and Plimpton, interviewing Andrew Ceresney about his time as Director of Enforcement at the Securities and Exchange Commission for the SEC Historical Society. We like to start with a little background about the interviewee and sort of your career, I guess originally to law school. So if you can tell us a little about where you grew up and where you went to school.
Okay. I hail from Brooklyn, New York, where I've lived 40 of my 47 years. So I'm a Brooklynite originally, and I live in Brooklyn still now. I went to yeshiva for 12 years, so Jewish day school. And then I was at Columbia for undergrad, and then Yale Law School for law school. I clerked for two excellent judges, Judge Mukasey, who subsequently became my partner at Debevoise. Obviously, he became Attorney General also. And then Judge Dennis Jacobs on the Second Circuit. And after that, I went straight to the U.S. Attorney's Office, where I was for a little bit more than 5 years, handling mostly securities fraud, white-collar cases. Then I went to Debevoise, where I was for almost 10 years. And then I went to the SEC as Director of Enforcement.
So if I can ask you a little about your work at the U.S. Attorney's Office. I know you were with the Securities and Commodities Fraud Task Force. Did something in particular lead you to an interest in securities fraud, or how did you wind up in that particular niche within the U.S. Attorney's Office?
Yeah, so I was always drawn to white-collar cases because, from my perspective, they're the most complicated to prove. I mean, obviously intent is typically the main issue in those types of cases. And it's complicated to sort of put together the proof of intent, and it's also, these are often very complicated cases. So I was drawn to that, and I actually I went to the major crimes unit, which is non-securities fraud, white-collar cases. I did a lot of money laundering there, and then I changed over to securities and did that for 2 or 3 years. And I found that one case that I handled that was of note. There were a number, but one was prosecution of Mickey Weissman, who was CEO of a company called American Banknote, and it was pre-Enron conduct. So obviously Enron was sort of the marker for when accounting fraud became kind of central in terms of criminal activity. He was charged before Enron and probably was the first CEO trial of a CEO for accounting fraud. So that was an interesting case.
Okay. At that time, I assume because of accounting fraud, you were working with people from the SEC, the Division of Enforcement of the New York office. Can you talk a little bit about I guess this would have been early 90s, mid 90s?
Late 90s, early 2000s.
Late 90s. Can you talk a little about your impression of them at the time and what the interaction was between the SEC and the U.S. Attorney's Office?
Yeah, I had a very positive impression of the SEC at that time. In some respects, the SEC was the client in the sense that the cases often derive from the SEC because they would typically bring them to the U.S. Attorney's Office, did a lot of the legwork and analytics before it even came to the U.S. Attorney's Office. And so I had a lot of good interaction with the SEC. They were, very committed people, really smart, knowledgeable, and experienced in securities law. So it was sort of a great dynamic. I actually tried some cases with people who were special assistant U.S. attorneys who were assigned, seconded to the U.S. Attorney's Office from the SEC. So I had a lot of contact with SEC folks.
Okay. And then you went to Debevoise for a decade before coming back as Director of Enforcement in 2013. Do you know what led you from Debevoise to the being Director of Enforcement?
Yeah, well, so, obviously Mary Jo White, who was appointed by the President or nominated by the President to be the chair of the SEC. I had worked with Mary Jo at the U.S. Attorney's Office. That was my first exposure to her. And when I was leaving the U.S. Attorney's Office, she had told me when I was ready to leave that I should give her a call. So then I had gone to Debevoise, in large part because Mary Jo was here, worked with her for 10 years here, mostly on the defense side. And then when she got the call from the White House, she gave me a call and said, would you like to come down and be Director of Enforcement? Now, obviously, I was excited about the opportunity, though I love to tell the story. that I called my wife because we lived in Brooklyn, right? And I clearly was not going to move to D.C.
Oh.
And so I was going to commute. So I called my wife to tell her the great news. It was like, I think, 9 o'clock at night. I was in D.C. And she hung up on me because she was like, what, you're going to leave me up here with, relatively young kids? We subsequently discussed it, and my wife is an amazing person, very understanding, and ultimately agreed that it was the right thing to do for many reasons. And so I ended up going down to D.C. with Mary Jo, and that's the story.
If I can ask a quick question, how easy was it to commute from Brooklyn to D.C. with a job as demanding as Director of Enforcement?
At the time, I did it for almost 4 years. At the time, I kept my head down, and I kind of was, in the mode and not really thinking about it. In retrospect, it was a difficult thing because I was away from my family during the week, usually Monday to Friday, or at the very least Monday to Thursday. And I think, listen, it does take its toll on your ability to be close to your family and the like. But my family is very understanding. My wife was, as I said, an amazing person, so we made it work.
All right. I want to return to Chairman White in a couple of minutes, but you obviously joined the SEC, leading in a period when the division leadership seemed to be drawn less from the staff than at a time when a series of leaders had been drawn from the U.S. Attorney's Office, Rob Kazami, but also the Deputy Director, also the head of the New York office, and your background as well. So what led to that? What led to, it appeared, to increasingly reaching out to federal prosecutors to head the division and to staff it?
Yeah, so I thought it was a positive thing. I mean, I think, federal prosecutors, a number of things make you a very effective, I think, Director of Enforcement. One is you've tried a bunch of cases, so you kind of know the case starting from an investigation through trial, and you sort of know what, how evidence will play at trial. And that's one of the things that I think I brought to the commission was this trial knowledge, trial expertise, and sort of a focus on trying cases and winning at trial. So that was one thing. Some of the tactics in the criminal side have been imported over the years to the SEC side, things like cooperation and cooperation with the criminal authorities and the like. And I think those kinds of things really are helpful as well. And then, of course, I think the other thing that I think was very helpful for me was having been in private practice for 10 years, which I think, there's obviously a lot of talk about the revolving door and whether that's a positive or a negative thing. From my perspective, it's very positive because I knew what the defense is thinking about, what the issues on their side of the table are, where I have the leverage, where I don't. And I was able to use that, I think, in my work as the Director of Enforcement, I hope effectively.
Did you perceive any concern in the Enforcement Division about having you succeed someone else who had not previously been on the staff?
I think there were initial questions. I think it's just a natural thing that people want to have people promoted internally. Mm-hmm. I think there's a benefit. There are some drawbacks, obviously, to having an outsider come in. There's also a benefit, though, because I think you kind of bring a new perspective and you don't look at things in the sort of prism that people who've been there for a long time look at them. And I think I was able to, over time, win their trust and, make them understand that I was there to advance what they were doing. I mean, I really believe that the people at the SEC are the highest caliber, really, really talented, really committed to the mission. And, my role was really to try to harness all that and really sort of, allow us to bring the most effective cases, but have the most, effective program that we can.
Sure. So when you first came to the SEC, you were actually serving as co-director of enforcement with George Canellis, and you did that for approximately a year?
8 months.
8 months. And I asked this question in part because they're currently co-directors of enforcement. So how did you and he handle running the division together in an arrangement that was really unprecedented and not been tried before?
Yeah, George and I go way back. We go back to the U.S. Attorney's Office and are very close friends. And I think that made it really relatively seamless. George is a great, smart, just talented lawyer. And having him there, he had been at head of the New York office and acting director for 4+ years. And so, I'm coming in from the outside. I need to learn the place. Having George there to sort of tutor me on the place and the sensitivities and, how things work was really indispensable. Another sort of useful thing was I was coming from private practice, so there was a number of cases that I was recused from, and so having George there to handle those cases was great. I thought it was a great transition, really helpful for me to allow me to get up to speed and get in the place where I thought, once he left, I was really able to function, at full speed without any issues. And so I thought it was relatively seamless. There were some cases we handled together. Most things we divided up the world. We thought about things very similarly. We consulted with each other when there was an important decision to be made, and I think it worked very seamlessly.
Okay. So you obviously joined in a period of major change in the division, though it had been 4 years since the financial crisis, 4 years since the Madoff scandal. It still seems that, and I should say that the staff was working through the remains of the financial crisis. It still seems as though they were recovering from some of the effects of that. In an interview, you said it was your goal to help bring the swagger back to the division. So I'm wondering, I guess it's two-part. What did you mean by that, and how well do you think you accomplished it?
Yeah, well, one thing I learned there is anything you say gets quoted back to you, and that was a valuable lesson to learn early on, and it was a relatively painless lesson to learn from that, because that's not a terrible thing. But what I meant by that was that I felt like post-Madoff, obviously the SEC took a major hit in the public's mind. I think the SEC for a long time, we go back to the Milken years, the Boesky years, the Sporkin years, the FCPA, you go forward to Enron and WorldCom, and you really had, the public view of the SEC was that it was a feared enforcer and that it was, really a cop on the beat. And Madoff obviously caused a lot of public, a questioning of those kinds of things, which was, in my mind, unfortunate. And I really felt like we needed to get back to where we were. A lot had been done under Rob Khuzami, my predecessor, who really did some amazing things. I'm sure we'll talk about some of them. But I still felt like there was still some ways to go to get back to where we were before. And so my point about swagger was to basically make the point that I wanted people to view us with some fear, but also viewing us as being the cop on the beat, and people to be proud to work at the SEC again, to sort of view it as a place where people are committed to the mission and doing, so-called God's work. And I hope that I do believe that we actually achieved a lot of that.
All right. Can you talk then a little about your approach to running the division? How did you run a staff of several hundred attorneys with a lot of different cases going on and a lot of responsibility?
1,400 people, actually more than several hundred. Listen, it's a managerial challenge. I actually had not been, a manager of large groups of people before, so it was a challenge for me. But I learned over time a number of things. One, you got to build a very strong team, and sort of putting people into leadership positions who were really talented. I always felt like the most important thing to me was obviously integrity and judgment, but also energy. And I focused on trying to get people into those roles that had that energy and could turn the program around in various parts of the program. I was also focused on making sure that people felt like they had the autonomy to do their job. I always felt like people did, a good job when they really owned the work, when they owned the investigations and felt like they could move them along and make decisions. I always wanted people to feel like they could make decisions. And my approach was basically, listen, there's always a range of reasonable outcomes that you could reach. Different people can reach a different decision, but that's not to say that the decision somebody else would make is unreasonable. There can be reasonable decisions. And my job, I viewed it as, making sure that people were making a decision in the reasonable range. Not to say that I always substituted whether I would have done something slightly differently for somebody else's. I wanted them to feel like they could make decisions without fear. I wanted them to feel like they could, move their cases forward, have their own ideas and initiative. And that's what I tried to foster, and I think it was successful in doing that, and I hope people felt that way.
Okay. I want to move on to talk about some various initiatives and some of the major issues that arose while you were head of the division. But a good way to start might actually be asking a little more about your relationship with Chair White and about the way that an agenda or the agenda for the division is developed, because I believe from at least public comments that Chair White clearly had some views about the particular direction enforcement should take, and so how you and she interacted in setting up the agenda.
So, Mary Jo and I had a pre-existing relationship and very close. And, Mary Jo was, incredibly important to setting the agenda. And, I would consult with her on big decisions, big issues. Obviously, every case ultimately she had to review. But I would give her a sense of what's coming down the pike, important cases that are sort of percolating up. And we would talk about those. She obviously spent a lot of her time on rulemaking, and she was very focused on that, and very focused on getting a bunch of other things, Post-Dodd-Frank, Jobs Act, other types of rulemakings done. So she obviously had a lot on her plate besides enforcement. But we obviously would consult very closely, and ultimately I think from my perspective, one of the most important things to a successful director of enforcement is the chair's support and the view of the defense bar, but also the commission and the staff, that you have the support of the chair. And I think we were able to sustain that, and that allowed me to have the latitude to sort of essentially, kind of when I said, what the decision was, people I think understood that Mary Jo would generally support that, and I think that was important.
Were there places in which you disagreed, or?
No, surprisingly, no.
Okay.
I think, on a particular case, we might have a slightly different view of things. But I would say, overall, we kind of agreed on most things. And, I think, we thought about things very similarly from a similar background.
Okay. One initiative that at least got a fair amount of attention in the press was Chair White's announcement of a broken windows policy, suggesting an approach of targeting some smaller violators. Why, I guess, two parts question, one of which would be, within the division, how important was this? And did it wind up being a significant part of your work?
Yeah, it got more attention than I think it really deserved.
Okay.
It was not a significant part of my work. And in fact, the idea was to try to limit the resources necessary to bring a bunch of cases together in areas where we saw significant amounts of violations. And the idea was pretty simple, which is if you brought 10 cases on a particular issue as opposed to just one, it would get more attention and it would have much more of an impact. And that was true time and time again. We brought cases on Section 16 violations, filing, insiders trading in securities and filings they have to make. We brought cases, the MCDC cases relating to municipal disclosures. We brought a bunch of cases, Rule 105 cases. So in each of these areas, we are seeing a whole bunch of violations. And what you really saw after we brought these cases and publicized them was, in those areas, a complete reduction in violations, which I thought was very important. It also set the tone that no violation is too small, and sort of sent a message that we were going to be looking for these things, so people are much more careful. There's been criticism, probably mostly because of the name. I think Mary Jo likes to say she would have liked to have called it Blitz and Bundle, but we called it Broken Windows. And that had whatever implications it had, but I think it was overstated. It was not a change. And in fact, I think you've seen in the last year plus, even post Mary Jo, cases like the Forum PF cases like the recent cases brought against companies that didn't get their auditors to review and sign off on reviews of quarterly financial statements. Those are very similar cases.
Okay. While we're talking about Chair White and about the commission, what was your experience dealing with the other commissioners? Because even though the chair obviously sets the tone, there's still, when the commission is fully staffed, there are 5 commissioners. Mm-hmm. And how does the Director of Enforcement deal with that particular setup?
Yeah, well, listen, first I should say, all the commissioners I served with, were very committed to the mission. They, and generally it's true that enforcement is a bipartisan exercise. No one's going to really object to punishing a Ponzi schemer or punishing an insider trader or a microcap fraudster. So really most of the cases are pretty unanimous. I think, listen, it is a little challenging when you have different points of view and you have to satisfy people. And I spent a lot of time with the other commissioners addressing their issues. And the other sort of thing you have to worry about is a particular commissioner may have a pet peeve on something, but you don't want necessarily a particular commissioner's pet peeve to influence what the staff does, because at the end of the day, that's just one vote, and there may be 3 other votes the other way. And so what I tried to sort of instill in the staff is, listen, we obviously have to count the votes. We need to know we need 3 votes. But our approach is to do the right thing. And what we recommend to the commission what we think is the right thing. And we hope we can count to 3 when we do that.
All right. I'd like to turn a little more to specific initiatives that you undertook as Director of Enforcement. One, which obviously was in connection with the Commission as a whole, which is before your time, settlements basically were neither admit nor deny. And it appears as though it was extremely rare, if not unheard of, for settlements to include any admission of guilt, I believe, unless there was a parallel criminal process at the time. And for the first time, you announced that there would be, in some settlements, a requirement of an admission of guilt. Mm-hmm. And if you could talk a little bit, let's start talking by asking why the change.
Mm-hmm. So, Mary Jo obviously had a huge role in this change. And the bottom line was, we felt that whenever there was a report about an SEC settlement, there was always the neither admit nor deny language included in the article, and there was always sort of a implication that there was not necessarily that person was admitting to it. And we felt there were types of cases where that just wasn't good enough, where we needed more than that, and we needed a potential, egregious conduct, effect on the market. We had a whole number of factors that we articulated that we would consider. And I think it was very effective. I think we had over 80 settlements with no admit, no deny, with admissions. And I felt like that was important in those cases. And I think it sort of gave us an additional remedy in a particular case where you had to admit to the conduct. Couldn't do it in every case because that would really sort of have very significant impact on our resource allocation and the like. But there were cases where it was definitely appropriate, and I felt like it did bring something more to those cases. That when there was an admission, we initially got a lot of pushback, like you're never going to get these admissions, and then we did get them. And I think we showed that it's possible to get them. People would admit to both the facts and to a violation of law, which I think is important in particular cases. And I think it really did add something to the repertoire. I would hope that it, going forward, there'd be, there would be admissions cases, but obviously, future folks need to decide. I should also note there was also a view in the public that cases with no admit or deny wasn't enough of a sanction, and so this kind of addressed some of that concern as well.
How did the first parties that you told that you wanted an admission, what was the initial response? Perhaps I'm asking you to wear your defense lawyer hat again. What was the initial response to the first group of parties when you told them that you wanted admission as part of a settlement?
No, a lot of resistance, but as we worked through it, they realized that ultimately that most of these things that they were going to admit to are things that they had to admit to. There was no way they could deny them. And so then it was getting them over the hump of the violation, and we essentially, we were able to do it. So I think there initially a lot of resistance, but over time it became easier.
Okay. Turning to another specific issue you dealt with, or perhaps a different way of putting it is, by the time you became enforcement director, it was almost 5 years after the financial crisis. And a lot of the cases dealt with by the enforcement division, at least, were fairly far along, if not concluded. What did you consider at that point to be new or renewed priorities for the division?
Yeah, so what I like to say about my tenure is that the good news was we didn't have a financial crisis or an Enron-like situation, which would have taken up tremendous numbers of resources. So it really did allow us to focus on the full spectrum of securities issues. We did focus more on financial reporting issues, which I think post-Enron and WorldCom had fallen off the radar a little bit. We doubled the number of cases that were brought in the financial reporting area.
Okay.
We also focused on investment advisor cases. We focused on market structure cases, a lot in that area. We focused on, obviously, insider trading, which is perennial. FCPA, also a relatively perennial area. And in each of these areas, we tried to bring important cases across the spectrum, and I think we were successful. I never felt like we didn't have at least the resources generally that we needed to address all of these things.
Okay.
And so that was, I think, a helpful thing.
Okay. I guess one of the topics I want to ask about was perceived as a new move back to accounting fraud, and increased attention to that. And I have to quote the New York Times article, which stated that you, or at least the commission, was bringing sexy back to accounting investigations. How did you accomplish that, if you did?
Yeah, well, we definitely did. Accounting fraud became sexy again. No, I mean, listen, it was, as I say, I think we doubled the number of cases. And one of the things that was interesting about it was that a lot of the cases didn't involve Enron-like conduct. And one of the questions we had when we started this focus was, are we going to see big accounting frauds at companies? And I think ultimately what became clear to us is that Sarbanes-Oxley did have a good impact broadly, that the certification process and the controls, internal controls that were implemented subsequent to Sarbanes-Oxley had a very significant impact on companies and helped them really avoid that kind of large-scale fraud. But at the same time, there were areas where there had been a failure to focus, and disclosure issues, revenue issues, other types of issues which we found issues in, and so we brought a whole bunch of cases under there. We also focused again on auditing very closely, and I think brought a whole bunch of an increase in auditing cases, including cases against Big Four firms. And I think there we also perceived that there had been some failures. Again, maybe it's all cyclical, right? So post Enron, WorldCom, you sort of had now a heightened focus. Then there had been some time, financial crisis, less of a focus, and now more of a focus. So I think all those things came together so that I think it was an increase in focus on this area, and I think we were successful on that.
Apart from the increase in focus, was it your perception that, for instance, accounting fraud itself actually rose and fell as a problem, or are we really talking about the ability that obviously during the financial crisis something else was on the top of the agenda? Is it merely a question of directing greater resources to it, or will you actually think that there was some resurgence of problems with accounting after a period of, say, Sarbanes-Oxley and Enron perhaps muting it?
I think this is probably more about resources and focus, because financial crisis cases really did take up a lot of space in terms of the enforcement docket. And so I think this was probably more about resource allocation.
Were any of the, I know they were related, but were any of the audit or financial or the accounting fraud cases particularly memorable, or do you think had particularly significant impacts?
Yeah, no, I think, so the cases we brought against BDO and Grant Thornton, I think were NEY relating to Weatherford were, I think, significant. They were real significant audit failures, and I think those were very significant. CSC, we brought a case against them with a huge penalty in that case. We brought some other, significant. One of the significant things about financial reporting cases is that they typically do involve individuals, and usually CEO, CFO type levels, and most of our cases had those types of individuals in them. So I think that was a significant aspect as well. So I think we made a good amount of progress in that area.
And CEOs and CFOs has.
Oh, sorry.
And obviously those individuals that had by themselves violated the law. Did you also see bringing charges against them as a way to perhaps send a larger message?
Yes, no question about it. I mean, and people have emphasized a lot in recent years the importance of individual accountability and cases against individuals, and definitely it sends a strong message. And I think I'm seeing it now on the defense side, because I obviously now I'm on the other side and I talk to CFOs, CEOs, and it really has had a tremendous impact on them in terms of deterrent value.
Okay, so one of the things you did was to start the fraud task force, but perhaps that leads to an organizational question, which is under your predecessor, the division had been significantly reorganized, branch chiefs had been eliminated, he had formed a series of specialized units. And so I wonder if you could talk about the utility of a greater specialization within the Division of Enforcement, and how well you found those units and similar attempts at specialization to really work.
Yeah, I thought that, and I mentioned earlier that Rob Kuzami had done some great things in terms of reorganizing, and that was one of the most important things, I think. Creating the specialty units, I thought, was really important for increasing expertise and focus in particular areas. And it wasn't only the attorney focus, although that was important. It was also the outside experts that were brought in. in each of those units who could keep track of what's the cutting edge issues in the particular area and really sort of bring to bear a lot of expertise in those areas. And that, I think, was indispensable. My view was that it obviously takes a number of years to see the fruits of a reorg like that, and during my tenure I feel like we saw the fruits of that. I'll just give one example. In 2014, in the spring of 2014, Michael Lewis came out with his book called Flash Boys. And it was about how the market is rigged, how ATSs or high frequency traders are trading in the markets and taking advantage of retail investors. And after that came out, the first thing I did was call the market abuse unit and ask them, what do we have going in this area? And I was able, over the next 2.5 years, to work with them where they were bringing really sort of cutting edge cases in this area. They had a bunch of cases already in progress. We were able to move them along to sort of bring those cases eventually. And having that expertise, including the outside experts, was just critical to that, because we had people who had been traders at investment banks and who understood how trading worked, where if you didn't have that before, there was no way you were going to be able to crack that area.
So that actually goes and might even have been a bit of an answer to the next question I had, but I'll ask you to expand on it a little, which is you became director during a period in which technology and the markets were moving very fast. We can give examples of algorithmic trading, as you said, high-speed trading, dark pools, for instance, alternative trading. So one of the ways in which that was addressed by the staff was clearly what you just discussed, by specialized units. Beyond the specialized units, were there other steps that you or the division took to try to keep up with a landscape that was changing very quickly?
Yeah, well, we did a number of things. One, we obviously coordinated with the other divisions, and DERA in particular had a lot of expertise. Mm-hmm. We created the Center for Risk and Quantitative Analytics, which was a group within enforcement that had quants and that could team up with enforcement attorneys to advance cases and to use analytical tools to do that, which was very effective. We just, as you said, increased expertise and people who focus on this area and bring multiple cases in it become very expert very quickly. So we had people who were staff attorneys who were really sort of steeped in these areas, and I think I remember when I first started, I read a book about dark pools. I'd never heard of a dark pool before. And so I even, again, I didn't have anything close to the expertise but I even started to get much more sophisticated about it over time, and I think that's the way you keep up. So
that actually, I do want to ask very quickly about staffers you worked with, and this is a little bit of a digression for where we were, but it seems a good time to do it. I know a lot of people within the division below the director level often go unsung, and I wonder if you can talk about perhaps a couple of individuals who you thought were particularly contributed a great deal, or whose work perhaps illuminated some of the trends we're talking about now.
Sure. I hate to bring up particular people. I'll mention a couple people. One, there was a staff attorney out in California. We talked earlier about admissions. We were in a meeting. We were talking about a financial institution, and I said, well, we should try to get admissions from them. And the staff attorney said, they'll never agree to that. And I said, no, they'll agree to that. And he said, no. And he sort of pushed back. I said, well, let's see. We went out, we got admissions from them. When I went out to visit the LA office, he gave me a lollipop that was a crow. And he ate the lollipop as I stood there, so he was eating crow. But it was clear that he had been sort of energized by, kind of having the ability to bring this case and also get significant remedies on it. So there was a number of people like that in investigations where I really felt like we were able to sort of empower people. And then there's also the people the regional directors that we brought on were really great. I mean, they really there were offices that were underperforming that they really turned around. People like Gina Choi and Sharon Binger and David Glockner and Shamoyle, Ship Chandler, and people who and Walter Jospin and others who I think really just sort of transformed their offices.
Okay.
And then Joe Brenner, who was chief counsel, was really just indispensable in terms of keeping us smart. And then Stephanie Avakian, my deputy, was wonderful.
Okay. Can you say a word about the regional offices and the interactions you had with them from the main enforcement in DC?
Yeah, sure. And I spent every year I'd go and visit every office at least once, sometimes multiple times. And I think that was important to sort of get out there and see people directly. And of course, I spent lots of time on the phone with people and tried to just stay in touch with what was going on in the regions. And I thought, each region I always felt like had its own kind of vibe, its own sort of thing that they were known for and thing they were really good at. Each office had its own sort of strength and its own character. And whenever I would go to the offices and visit, I'd also do a happy hour. So I get to know people, in more of a relaxed setting. I thought that was important.
Okay. Moving on, I want to talk about some of the developments stemming from Dodd-Frank. Mm-hmm. And let's start with the new authority granted to the administrative process and to the Commission's administrative law judges. And there was certainly an apparent move to bring more matters in front of, through the administrative process at the Commission rather than through federal courts. And I wonder if you could talk a little about that.
Yeah. Well, so first of all, I think that was overstated to some extent. Obviously, a lot of settled cases were brought as administrative proceedings. I don't think anybody complained about those. Litigated cases, we actually kept bringing, frankly, the vast majority in district court. But we certainly brought cases in administrative proceedings that we could not do before Dodd-Frank. We brought, for example, 2 or 3 insider trading cases, and we brought some other cases. And there was, a lot of opposition to that. I thought the opposition was kind of misguided. I mean, the view was that it was actually unfair because we had an advantage in administrative proceedings. And I think time has shown that actually we didn't. And in fact, I thought we did actually worse in administrative proceedings than we did in district court. And frankly, over time, I kind of realized that. Like, I don't know that I fully understood that when I first started, but by the end, I was certainly conscious of that. And so by the end, I really felt like, most cases we were going to bring as district court cases. There also was the litigation that involving the Appointments Clause issues.
Yes.
That ultimately made its way to the Supreme Court, and once the Department of Justice flipped, ultimately went against the SEC. And we were obviously focused on that when I was there, and worked very closely with Annie Small, our general counsel, on that. And I think, listen, that was a challenge that was really to the appointments issue. It really didn't go to the merits of administrative proceedings. And it played out the way it played out. Ultimately, they'll now have to retry a whole bunch of cases. It'll be kind of disruptive. But, I think over time, I think what all of this probably showed is that, frankly, administrative proceedings probably are best for a particular type of case. That was the type of case that was brought historically there, and that probably will be what they're used for going forward.
Okay. On the other hand, having said that, you also apparently beefed up the trial unit, or at least there was greater discussion about the trial unit and the willingness of the Enforcement Division to bring matters to trial. And why did this seem important in 2013? Why the new emphasis on willingness to go to trial?
So a few things. First, just so while I was there, I think we hired 26 former AUSAs in the trial unit, which I thought was a very important thing because I felt like we needed people who had experience trying cases and who really could try cases. So I think that was important. From my perspective, like, you're only as good as the litigated case that you can win, because the only way you can get good settlements is if people fear taking you to trial and they know that you're going to win at trial. So I always thought that was really important. I placed a lot of emphasis on trials because, to me, again, winning set us up for settlements, in cases where if we won, people would be. When I first started, early in my tenure, we lost 5 straight trials. And there was a lot of press about the SEC can't try a case, can't win a case, et cetera. And it was really unfair because those 5 trials, included the Cuban case, but others. Mm-hmm. And there were lots of reasons why we lost those trials. But I sort of devoted myself to the fact that, like, listen, this is not going to happen again. And so I would do things like I'd have a moot for every opening. I'd follow the cases closely as they were going along. I'd be very focused on what's going on in the cases, and to the extent there were strategic decisions, I got involved in those. I tried to attend as many trials as I could, and I made sure that we had the right staffing on the trials because I wanted to make sure that we had the right people trying them. So I did a bunch of things like that. Matt Solomon, who was chief litigation counsel, was excellent, and he was very focused on these things too. And so I think ultimately, frankly, in the last 3+ years of my tenure, I don't think we lost a district court case. We did lose administrative proceedings, but I don't think we lost a district court case, and or maybe one. There might have been one. And I thought that was a testament to what we had done, and I really feel like these days, the other story I'll tell is when I first was going to go to the SEC, one of my partners at Debevoise, who shall remain nameless, joked with me. He said, the SEC can't try a case. And then about 2.5 years into my tenure, we actually had a trial against Debevoise at the SEC, and I was obviously representing the SEC. And I would go to the trial, see the trial. Ultimately, the SEC won the trial. And so, afterwards, I told the partner who said this to me, who wasn't one of the trial attorneys in that case, I said, what do you think? What do you think right now? And he says, yes, I guess you guys can now try a case. So I really felt like we made great progress there, and I thought that was important.
Okay. Would you be interested in commenting on the Cuban case?
Probably best not to. The only thing I'll say about the Cuban case is that bringing it in Dallas, I thought really sort of put you at a disadvantage. I think the case could have been brought elsewhere. But, the result is what the result is, and, obviously we respect the jury's verdict.
Sure. Another big or another significant development stemming from Dodd-Frank was the Whistleblower Program, the opening of the Office of the Whistleblower, and even though Dodd-Frank passed in 2010, it seems as though that was really getting up to speed when you took office. And can you talk about both how that was used within the division, and I'm also curious about your impression of the ultimate impact of that?
Yeah, I always called, and I continue to believe this, that the Whistleblower Program was transformative because it really gave us, gave the SEC a window into cases that you just didn't have if you didn't have whistleblowers. And you have to incentivize people to come in, and it was really sort of getting going, frankly, while I was there, and I think picking up steam because it takes a number of years for cases to work their way through. And I think it was really successful. I think we brought a whole bunch of cases we wouldn't otherwise brought. In terms of awards, they've now gone through the roof, and I think that's a positive thing. And I think ultimately it will serve the SEC well to have that. I think whistleblowers, not every whistleblower is going to be reliable. I mean, obviously, there's going to be people who raise issues that just aren't, the case, either because they're not familiar with all the facts or they're misguided or whatever. Mm-hmm. But there are going to be people who have legitimate issues, and I think incentivizing those people to bring the cases, I think, is great. And I think it's ultimately, the other thing that developed while we were there was the whistleblower bar. So a bar of people, lawyers who represent whistleblowers, and that was really important because they essentially developed the cases, it's more like a triage system for the SEC, and I thought that was a very positive development too.
You might not know this, but was it expected that a whistleblower bar would develop, or was this a surprise?
I think it was somewhat expected because False Claims Act, which is another area where you have similar whistleblower type rewards, it had grown up in that area too. So I think there was expected that there would be. Okay.
I'm aware there have been some studies showing that there were whistleblowers in a number of areas. Is there any particular area of enforcement where you felt that either whistleblowers were most useful or perhaps open the door on activities that you really were unaware of before?
That's a good question. I don't know. It could be accounting issues potentially are areas that where they'd be uniquely situated. I mean, usually the things where they make the most difference are things that are hard to detect. And so accounting fraud is one. I don't know that I could point to another area, though.
Okay, let me move on to talking about some more specific areas you've mentioned briefly earlier, but it'd be nice to spend a little more time on. Starting with the increasing number of cases against investment advisors. Mm-hmm. And I wonder if you can talk a little bit about how that issue came to the fore, or how those cases came to the fore during your term.
Yeah, so obviously investment advisors traditionally have been a subject of SEC focus because they're registrants and the like. And so that has been, but I think that sort of the twist was with the creation of the specialized unit and with the asset management unit, which now was very focused together with OC. They really teamed up with OC to focus on particular areas that really for a long time had not been focused on before. And so I think it was an opportunity to sort of really sort of send messages in areas that had not gotten focused before. I mean, one example would be the private equity area. Post Dodd-Frank, private equity firms had to register, and so that then they got to be examined, and that led to the finding of various issues relating mostly to fees and expenses, and that led to enforcement actions and led to big changes in the PE realm. And I think, I think those types of impacts are really what distinguishes an effective enforcement program when you see that kind of change in an industry. And I think the asset management program and the asset management cases really had that impact.
So that, perhaps I can just ask you to spell out a little more. So there was clearly an attempt, there's been an attempt with a number of directors, including you, to target, maybe this goes back to broken windows, I'm sorry, you said it was bundle and blitz?
Blitz and bundle.
Blitz and bundle. To target what you perceive as specific problems within an industry and then put a significant amount of resources towards them.
Yes, and that, I always felt like that was the way that you look at, one of the important ways you look at the efficacy of an enforcement program is, do you have, almost immediate impact on an industry by bringing cases? And I thought PE was one example. There were others like market structure cases in the ATS area. Brought a bunch of cases there, and I think it led to, big changes in the ATS realm, similar things in the municipal area. And so I think that is one of the, you try to publicize, that's one of the reasons you publicize your cases, is so that they have the impact. And people are watching very closely what the SEC does. And so when you bring a case, it could have a significant impact.
What did you think was going back to the PE, what did you think was the particular significant cases there? And perhaps spelling out what impact did that have downstream?
Yeah, well, obviously, brought cases against a number of the major PE firms. And again, most of those cases involved the disclosures relating to fees and expenses that they were getting from portfolio companies over time, accelerated monitoring fees, things like that, and whether they had appropriately disclosed them to investors at the time the investors invested or even afterwards. And so those cases, I think what that has led to is some of the criticism was, well, we have very sophisticated investors on the other side, and they know what we're doing. But I think what became clear is that, even sophisticated investors don't necessarily know 100% what's going on. So you clearly had lots of changes in the PE industry in terms of fees and expenses and how they're disclosed and what kinds of fees and expenses they have and whether they're offset against management fees, those kinds of things. And so there's been those kinds of changes. And I think, frankly, the PE industry has been incredibly responsive. And I think what you've seen is, I don't think you'll have those kinds of cases in the future, because I think now they've gotten, they've changed the practices, and I think it's a place where people really are focused and have made, positive changes.
Okay, were there comparable cases in the ATS space?
Yeah, there were. There was cases against CS, cases against Deutsche Bank, cases against other Barclays and others, and I think the issue there was the disclosures of how they were going to do the trading, whether they were going to allow aggressive traders to trade, and whether they were going to have sort of mechanisms for trying to weed out those kinds of traders, and if so, were they actually employing those mechanisms? So it's really all about disclosures that they made about the way in which the markets worked that ultimately weren't exactly true.
Okay. Can we...
I'm just going to fix your tie real quick.
Sure.
Thank you.
Pretty good. Can you talk a little about the municipal securities space as well? Because that was obviously another area of significant emphasis during your time.
Yeah. Well, so the municipal securities space, mostly, frankly, because of the Tower Amendment and other things that limit what the SEC can do in that space, is really kind of the wild, wild west. And I think it was recognized as such. And so one of the specialty units that was created was the Muni unit. And I think we actually changed its name to the Municipal and Public Finance Unit. It originally had been called Municipal Securities Unit, which we didn't think was exactly, we wanted to be broader. But in any event, we were very focused on bringing cases in that area, cases that were really first of their kind. And what you really have to do in that area is use the fraud statutes, because you don't really have regulations around filings that the municipalities file. And you also, your other piece of leverage there is over the broker-dealers and the registrants. And so you try to use those levers to try to change conduct in those areas. So we brought a bunch of cases that I think, had that impact. Probably the most prominent one is the municipal, the MCDC, Municipalities Continuing Disclosure Initiative, which was a cooperation initiative where we had both broker-dealers and municipalities self-report violations of their continuing disclosure obligations. And that, overnight, changed the disclosures, and so the industry now was much more compliant. And I think, that kind of impact was what you're looking for. I think we had, listen, there's more work to be done in the municipal area, but, I think by the end, I think there was a lot of significant messages sent in that area.
So obviously when you're dealing with municipal securities issues, plenty of the claims are against broker-dealers, but some are also against political units. And that's perhaps a segue to a question about whether you ever felt any political, there'll be media criticism inevitably, but whether you felt at any point there was any political criticism or any attempt to perhaps change any of your activities through you being an agency funded by Congress. What kind of political criticism you might have gotten, if any?
Well, we obviously got letters from Congress, and we got, we had to meet with staffers at times about certain things. But I never felt like we were, at all influenced by any political considerations. I really felt like we were essentially charged with doing the right thing, with enforcing the law, and without any sort of impact by politics. And we stuck to that. We would open an investigation if it was politically sensitive, if we thought it was appropriate to open it. And we would close it if we thought it was appropriate to close it. And we weren't influenced by politics. All
right. Some of the initiatives were new. Some of the initiatives, some of the issues that are faced the enforcement division, as you mentioned, are perennial. So if we could talk a little about insider trading. And some of the big insider trading cases had already been brought by the time that you became director. But I'm still curious about the emphasis on what emphasis was there on insider trading during your time? Was it increased? Was it something that continued but not a special emphasis?
Well, insider trading, as you say, is a perennial issue for the SEC. So I think, obviously we brought some very significant insider trading cases while I was there. Cases like, for example, the case against Billy Walters, who was a very notorious gambler. It was a great case. Ultimately, was convicted after trial. Leon Cooperman, a very well-known portfolio manager and hedge fund manager in New York. Cases involving political intelligence, which was a new area, including the Deerfield management case that ultimately resulted in convictions here in the Southern District. So we brought a whole bunch of important cases.
Yes.
But I think the other sort of trend that you saw, first of all, it was, in terms of number of cases, very high and also consistent, but also was the increased use of data to make those cases. So historically, the SEC insider trading cases were originally sourced mostly from FINRA referrals. So FINRA would detect conduct through their surveillance, and they would refer it to the SEC, often after working it up a bit. And what the SEC started to do over time, and increased during my tenure, was essentially they had billions of lines of blue sheet data that they had, kind of over time compiled. And we developed these analytical tools that were able to sort of see patterns in the data that would suggest insider trading. For example, if you had 5 traders making profits on the same 5 trades, that would suggest there's something going on and some connection between those traders. And so we had quants and analytics folks who were able to sort of parse that data, people like John Rimus in the Philly office and others, and really sort of just make cases by going into a room, spending an hour, and finding these patterns. And that I thought was very significant. It really sort of, it also had the impact, like if you got a referral, you'd go and do that kind of looking and then build out the case a lot. So that was significant. The other sort of significant development was the hacking cases. So cases where often foreigners would hack into places get information, trade upon them, and then ultimately make money when the information became public. And like the Newswire cases we brought were very significant cases in that regard.
Am I right in remembering there was a little challenge in applying insider trading cases to those laws initially? Or the insider trading charges, pardon me.
Right. Yeah, the Second Circuit in DeRosco ultimately concluded that hacking amounted to deception, that therefore could be insider trading. So I think the law is pretty clear in the Second Circuit, which is obviously the most important circuit in that area. So I think the law is clear that amounts to insider trading. But you're right that there was at least initial ambiguity.
Was there, I'm trying to remember, the Newman case was 2016?
14. December
So
2014.
So you obviously, it must have made an impact.
Well, it did. I mean, obviously, the Southern District of New York, I think their view was that it was going to have a devastating impact on insider trading. And it obviously did result in reversals of particular cases, so it obviously had an impact. But I always felt like when you looked at the language in Newman, you could interpret it as not having the huge impact, because you could see in there that personal benefit also included intent to it could be quid pro quo, or it could be intent to benefit the tippee. And I think, from my perspective, the intent to benefit, as long as that was still viable, I thought most cases would be able to be brought. And over time, the Salmon case and some of the subsequent cases, the Martoma case, I think it became clear that Newman didn't have the impact that I think people feared initially. Okay. It obviously was a significant case, but I think ultimately had less of an impact than people initially thought.
Okay. So you mentioned that the insider trading cases there were quite a few, but they were fairly consistent over time. So you didn't have a sense that insider trading was perhaps increasing during the period we discussed, or?
No, I think it was relatively stable over the years.
Okay. I guess I want us to wrap up, but I want to ask a question. Are there issues or are there things you remember as enforcement director that you think are significant that we haven't covered during this conversation that you would want to be remembered?
Well, listen, I mean, I think, when I think, we haven't talked about the FCPA. I think there were some very significant FCPA resolutions, particularly cross-border resolutions with other countries that I think were important. And that was a trend that began under me, and Kara Brockmeyer, who was chief of the unit, really did an outstanding job there. I think the market abuse unit really did great work in the market structure area and the ETS area. But I think we've covered a lot of ground. Okay.
Wrapping it up, how do you think the enforcement division changed during your time?
Yeah. Well, it goes back to what we talked about early on. I really feel like during my tenure, and again, it's because of the work of the enforcement division folks, that I thought the enforcement division got back to where it was pre-Madoff, frankly. Okay. And I think we essentially, I think morale during our tenure was extremely high. I think best places to work survey, I think we went up by 20-30%. And I think people really sort of had a pride of working at the SEC, working in the enforcement division. And I think we made, great progress. I think there was a view that, we were the cop on the beat, and that, where there were violations, we were going to bring a case. Albeit, I think it was important to be fair and reasonable. I think people perceived us as such. And I think the other thing is, I think people felt, I hope, that I was, supportive of what they were trying to do. That I think, again, I always said, what we accomplish is because of the people who are working in the division and really day in, day out coming into work and really sort of wanting to achieve and advance the mission. And that was why we were successful as we were.
All right. Thank you so much for your time.
Thank you.